is, it wasn't me. We have shown you that defense is not available as a matter of plain law, but it is not also available as a matter of principle. I propose to leave it at that point, Mr. Speaker, to share the remaining minutes with my learned colleague, Mr. Muvenge Jacob Ngwele, who will take you to the specifics of what is the case we brought before you, what is the response to that case, what are the admissions the governor made at the county assembly, and when all that is done, we shall beseech you in the name of God, whether it is the Christian God or the God of the Nyambene and Mount Kenya hills that they are Meru worship before the current civilization, that the time to stop this madness in Meru has come. And if there is no reason, if we haven't proved or satisfied you, the governor is the bishop in the Holy Book. In the event we have not persuaded you on the evidence, Mr. Speaker, I hope we have persuaded, wherever the truth lies, there is an unsustainable crisis in Meru. And even if you must jettison one person to save the ship, called Meru County with the 1 million inhabitants, your act is still justifiable even under the Holy Book. I now cede the floor to Mr. Jacob Ngwele.
Just to remind you, Council, your time terminates at exactly 8:50.
Thank you very much, Honorable Speaker. My name is Jacob Ngwele. I'm an advocate of the High Court. I've been given this onerous responsibility of taking the House through the evidence which has been submitted before the August House. Mr. Speaker, the Senate is sitting here pursuant to Article 181 of the Constitution, which provides for removal of a governor from office. The question which arises and which begs this House to look at, what is the standard which this House should apply on the evidence which has been submitted by the County Assembly of Meru? My learned colleague, my learned senior, Elisha Goya, when we started, he did inform the Senate that this House is sitting in quasi-judicial proceedings. I beg to differ. The test applicable when you're evaluating the evidence which has been submitted here has already been established by the Supreme Court in 2 cases. That is, the first one is the case of Wabora, and the other one is Mike Mbuvi case, whereby the court was clear that impeachments are a tool of political accountability. Impeachments are not criminal, neither are they civil proceedings. And therefore, the standard, the applicable standard before this House has already been established that the burden of proof, the standard of proof, is slightly above that for civil cases, that is on a balance of probability, and below the beyond reasonable doubt. So, this House is not evaluating the governor's criminal culpability, but it is subjecting the governor to political accountability. Political accountability for the actions of the office which she occupies and the deeds which she has undertaken throughout that period of time. It is our submission that the County Assembly of Meru has demonstrated and proved its case in accordance with the standards and tests which I've laid out by the Supreme Court in the decision. And I'll proceed to take this House through the specific violations which have been submitted. Mr. Speaker, the charge sheet before you has got 7 counts. And out of the 7 counts, those 7 counts consist 39 specific violations. And the first count, which of course is going to be read later on, is misappropriation and misuse of county resources. Article, I can't read the time.
You have 30 minutes.
Good. Thank you. Article 181 of the Constitution provides the grounds which the governor can be impeached on. That is gross violation of the Constitution, gross violation of the laws, that is conviction, criminal conviction on breach of the national law. We do submit that on count number 1, that is misappropriation and misuse of county resources, this charge has been substantiated and proved. And I'll proceed to explain to this House or demonstrate to this House how this charge has been substantiated. When you look at the charges, we have drafted them that the governor has engaged or by connivance or complicity. So the governor is implicated either directly or indirectly. What my learned colleague Mr. Mudomi has said, that it's not about the governor's direct action, so that if the Senate finds there is no direct or individual responsibility on the part of the governor, then the governor is going to be acquitted. No. There are instances when the governor is complicit or connivance or part of that violation, and that is what we are going to prove. This charge, the first one, is about embezzlement of county funds and withdrawal of county funds. A lot of energy has been dispensed here to demonstrating how a total of 78 million was, I can use the word, looted, swindled, plundered, or carted away from the Meru County Treasury. And this swindling involved a scheme which comprised a clique of 2 groups. One was a clique made up of governors' relatives. And all of you have heard names: Miriam, Rose, Kenneth, the Guadai, and also Meme. This was a clique, an inner circle clique of the governor, which was used to pilferage money from the county treasury in the name of interest or prepayments. The other clique was a group of officers working under the office of the chief of staff. Collectively, this group of people swindled an amount of 78 million shillings over a period of 1 financial year. The interest, the IFMIS data which has been produced, if you do a total computation, and this amount of money has not been disputed, none of the witness from the governor's side has disputed the totality of this amount. What they have done is that they have only submitted evidence to justify an amount or to account for an amount of 2 million only. What they have not done, they have not brought evidence to justify the balance of the 70 million. This group, the first clique, was responsible for 6.5 million shillings. The other group, that is the chief of staff and his officers, they were responsible for the balance of the amount. And in that group, you'll find a person, I'll just single out the individual, by the name Kadhure Rukaria. Individually, over a period of 1 year, she was paid in form of prepayments an amount of 21.8 million shillings. We have sat here for 2 days. No document is in front of you justifying that payment. Nobody has disputed whether this payment was withdrawn from the county treasury. Nobody. No documents in form of a payment voucher, an interest warrant, has been submitted to justify. There has been a deliberate attempt to distort the story and to focus the attention of the Senate to the interest. And the narrative is this amount of money was being paid as a form of facilitative interest for the governor's entourage. Can a governor's entourage collect a totality of 78 million? The amount of money which has been accounted for is only 2 million shillings. Where are the documents? Where are the vouchers? And when we asked, when the assembly requested for the documents through their summoning powers, they were told that the documents are with the Auditor General. And in the letter, which is in the document, which is in the bundle of document, indicates that the documents are being used for preparation of financial statements. Everybody who has got elementary accounting knows very well that you don't generate financial statement using vouchers. Financial statements are generated using cash books and ledgers. And even if these documents were taken to the Auditor General, where is the delivery book? No evidence has been submitted to show where that amount of money to support that expenditure. And in absence of such document to controvert this allegation, we do most humbly submit that this allegation of investment of funds has been proved. On their defense, what they attempted to do, they submitted documents here, a bundle of documents, which we have raised issues about its authenticity. We do submit that these documents were afterthought. They were generated ex post. They were ex post creations to justify those two, and they were not, in the attempt to justify, they only justified 2 million shillings. When they had an onerous obligation of justifying 78 million. Those documents were not signed, they were not examined, they did not comply to elementary accounting standards applicable to any accounts department in a public institution. So we do ask the Senate to disregard that defense which has been put forward and know that 70 million shillings, as we sit here today, has not been accounted. They had the obligation, they had the responsibility of calling in the Chief Officer Finance. They had the obligation, they had the opportunity to call in the CC Finance. They had at their disposal the entire county treasury to come and explain those amounts of money. They have not, and for that reason, we do submit that this allegation, that is count 1, has been proved. I'll swiftly move and quickly to the other parts of the other count. The next count is count 2. That is nepotism and related unethical practices. We do submit again that this count has been substantiated and proved. This count involved fraudulent, 2 violations. I'll just pick up 2 violations because of the interest of time. One was fraudulent misrepresentation of the governor's relatives as technical team. When the governor received an invitation to go to China, to visit China and do a benchmarking on a cancer machine, instead of governor sending a technical team, that is a top-notch oncologist or other technical team, the governor decided to send members of the same clique, which was made up of our relatives. 2 sisters, 1 brother. These are the team which was the inner team. This is a team which was sent to China. And you look at the documents which were presented to the Ministry of Devolution, there was apparent misrepresentation by the county secretary that these are technical officers. These are technical team. And the document is there. You have been shown the document. And we do submit that an argument has been raised here that no public funds was lost. But the County Assembly of Meru states that an opportunity was lost. Those who have done accounting or maybe economics, I think it is in economics, there's something called opportunity cost. The cost of not doing something. The cost of not doing something. That is the cost which was incurred by the County of Meru. And there was that violation of misrepresentation. The letter was addressed to the governor. The governor cannot run away, as my colleague, Mr. Mudomi, has said, and say it was not me. The letter was addressed to the governor. She minuted it to the officers, and the officers went ahead and misrepresented those members of the clique as county technical officials. The other violation in this particular count is the designation of Nefad Kinywa, who is a member of the clique. This is a clique which had access, power, and influence. And the clique involved the sisters, 2 sisters, and the brothers. It's the one which runs Meru today. So Nefad Kinywa, in order to reward him, when he was in a small job group without competitive process, and the governors admitted in cross-examination that his appointment was not sanctioned by the County Public Service Board. It has been admitted. Kinywa was appointed as a director external linkages without a transparent and competitive recruitment process. We do submit that count 2 has also been substantiated and proved. I'll move quickly again because of the time we have been given. Of course, it's so difficult to condense all the evidence which have been given within the short period of time which I have, but I'll try my best. The third count is count 3. That is bullying, vilification, and demeaning other leaders. Chapter 6 of the Constitution was not made in vain. The Chapter 6 of the Constitution operates with other laws. Principles key above them is Public Officers Ethics Act and the Leadership and Integrity Act. If you look at those provisions of the law, and those are the ones we have said the governor violated, I'll direct the Senate to Section 9B of the leadership of the Public Officers and Ethics Act, which states that a state officer shall not bully any person. It's there. There's also a call for professionalism within the Leadership and Integrity Act. There's also the professionalism means that a state officer shall treat the public and his fellow public officers, now these are public officers, with courtesy and respect. The aspect of acting through others has also been brought forward within those laws, and it makes it an offense for causing everything to be done through other persons. My colleague, Mr. Mudomi, has mentioned that the governor is now hiding, that it was not me, it was the county secretary. The county secretary has become the bogeyman. But the law, the drafters of the law knew very well that state officers and public officers who hold positions of powers will throw away responsibility. They'll shift responsibility to their juniors. And that's why the law says that you cannot run away from that responsibility. One of the violations under this particular count was actions against the deputy governor. I'll just bundle them to that. We've put several violations against the deputy governor. Key among them is that the governor made the deputy made a deputy the bogeyman, the symbol of hatred in Meru. And by that, she orchestrated a well-organized campaign to vilify the deputy governor and excluded him from performance and discharge of public duties. That is, attending CC's meetings and performing and discharging all the other functions. Evidence has been adduced. Sufficient evidence has been adduced demonstrating how these actions were perpetrated. The Hansard of the County Assembly, their letters by the Deputy Governor, writing, beseeching the Deputy President of this Republic, beseeching the Chair of the Council of Governors, to the Speaker of the Senate, asking for reconciliation, asking for these institutions to facilitate a reconciliation between her and between him and his the boss, that is the governor. There are memos which you have submitted demonstrating whereby the deputy governor is asking for simple facilitations like repairs for his cars, fuel for his car, staff, and the like. We do submit that this violation, this specific violation, has been demonstrated. What the governor has done has turned the battle on the deputy governor. Instead of justifying or explaining, now the deputy governor has become even the author of these impeachment proceedings. They have created a narrative around the deputy governor. Evidence has been adduced to support the vilification of the deputy governor in form of WhatsApp messages where the governor proceeded to engage in cyberbullying. Cyberbullying in WhatsApp. The governor is on a WhatsApp group, and there she has not disputed those screenshots. She has not disputed authenticity, the context of those screenshots. You can see the governor posting and talking about, and the DG mobilized fewer levies. Some people will find a way of defecating avocado seed. It's there. She has admitted that she has admitted that. Another posting. He thinks I'm the type of person who can be scared. That's a governor. And this is on a WhatsApp forum or WhatsApp group which consists public members, members of the public, senior officers of the county, junior officers of the county, and here it is the governor now vilifying a fellow state officer, which is in clear breach and violation of the provisions of the Leadership and Integrity, Chapter 6 of the Constitution, and the Public Officers Ethics Act. The other violation which falls under this particular account is that, and this is a violation which was here, and this is a violation which was before this House in the previous impeachment proceedings. That is, the governor has persistently been making demeaning public utterances against other elected leaders. Apart from the deputy governor, who was the bogeyman, who was a center of attack by the governor had other leaders at her crosshairs. Those are the elected leaders of Meru. All of them, the 12 of them, including the member of the Senate, the women rep, and the elected members. And this one was done through falsely accusing them of cartelism. The governor has grouped these leaders into one group and calls them a cartel. And this one, evidence has been produced or adduced before this House in form of videos. And I'll take you through one of the videos which has been played here about Wanyonge. Wenye wivu wajinyonge. And you can see the spouse of the governor playing a guitar and the governor behind dancing. And when the spouse talks about wenye wivu wajinyonge, she does it. So it's basically mocking the leaders and telling them you can do nothing. So that is kind of evidence which has been produced here. We've submitted that the issue of the governor's spouse has been a hot issue in Meru. What happened is that the governor provides the spouse with the platform. The spouse is used as the attack dog. Instead of the governor attacking these leaders directly sometimes, she uses the spouse to attack them through music and innuendos. The other video, which was submitted here, was during the presidential function in Larry, whereby the governor, it was played here, and the governor singled out the 10 leaders, and called them names, and falsely accused them of being members of cartel and trying to blackmail a regime. Honorable Speaker, we do submit that this count 3, that is bullying, vilification, and demeaning of other leaders, has been proved. Before I jump to that one, we brought a witness who is a member of parliament. That is Honorable Mugambi the Ndikiri. He is the chair of the Meru, the members of parliament caucus, and he explained to details the pain and suffering they have undergone as leaders by the actions of the governor vilifying them, and what he felt together with the other members when they were vilified during the presidential meeting, when he felt insulted, demeaned, humiliated, when they had not provoked the governor. We do submit that this allegation has been substantiated. I'm moving quickly to my fourth count. The other count, Madam Speaker, the other count which was brought before this House, which we believe is something which this House needs to look at deeply, includes the violation of the law. Count 4 is illegal appointments and usurpation of statutory powers. The violations are there in the charge sheet, the specific laws which have been violated. I'll mention a few violations which are there. One is the illegal appointment of the chief officers. A chief officer, and a name has been brought, evidence has been adduced. That is on page 296 of our document, that is on volume 2. The appointment of Kenneth Riungu as chief officer without the approval of the county assembly. Honorable Senators and Mr. Speaker, the County Government Act, that is section 45, provides for appointments of chief officers and the method. The governor nominates nominates from a list which has competitively been sourced by the County Public Service Board. And once the nomination has been undertaken, the name is forwarded to the Assembly for vetting under the provisions of the Public Office, that is the County Assembly's Public Approval Act. This particular chief officer, nobody has disputed his appointment. Nobody has said here, the governor, the witnesses, nobody has said that Kenneth Mwiti Ryungu has not been appointed or does not discharge the functions of the chief officer. This evidence has been produced. We do submit that the appointment has been produced, the evidence of the appointment has been produced in form of the letter dated 23rd August 2023, which contain a list of appointments which the governor made. And in that list, you will see the name of Kenneth Ryungu being appointed as a chief officer. The County Assembly of Meru has never vetted this particular individual, and this particular individual still discharges the functions of a chief officer in Meru. This is a violation of Section 45 of the County Government Act. The other appointment was the acting appointment of chief officers. Mr. Speaker, the same letter contains the names of several chief officers who were appointed. That is Edwin Mutuma Murangiri, Kenneth Gitobu Nikata. These were appointed as acting chief officers without the requisite competitive recruitment and recommendations by the County Public Service Board. Evidence has been produced in form of a memo by the County Public Service Board warning the chief officers against making acting appointments without the authority of the County Public Service Board. And the County Public Service Board in the same letter, in the same memo says, any appointments made without the approval or without the authority of the County Public Service Board, such appointments shall be null and void. These individuals, the governor has admitted that these were directors. We found them there as directors, and they appointed them as acting chief officers. Mr. Speaker, I've never, in my history, in my brief history in life, that is, I've never seen a director being appointed a permanent, that is a principal secretary. In case there's a vacancy in the office of a principal secretary, one of the principal secretaries doubles in that particular office because the appointment for that particular office is special and specific. You cannot plug in an individual from the ground and you make that particular individual an acting chief officer. So this one is a demonstration that the governor usurped the powers of the County Public Service Board and made this illegal and irregular appointments. Of course, there was the issue of appointment of traffic marshals. That violation has been demonstrated. The County Public Service Board, in their letters, they are very clear that they have not approved such appointments. They have demonstrated the same, but in the bundle of document, you can see the same traffic marshals wearing uniform, riding motorcycles, and the governor posting on WhatsApp that these are going to be the frontline officers to make Meru the next city. Who appointed them? The governor circumvented the powers and functions of the County Public Service Board and by herself appointed these particular individuals. The other appointment, the other violation was in regard to with regard to sending the 4 CEOs of the corporation, that is the parastatals in Meru. That is Dr. Ntoiti, the CEO of County Revenue Board, Paul Mwaki, who testified here, the CEO of Liquor Board, Kenneth Kimathi, the Managing Director. These are CEO of statutory corporations. They are employees of the boards. They're not the employees of the governor. What the governor did, through the county secretary, of course, they were sent on compulsory leave with pay. It only took the intervention of court after 1 year. That's when they have resumed their duties. The boards are the ones which recruit. The boards are the ones with the statutory powers to suspend or exercise disciplinary control over their CEOs. It is not the governor crossing over. I've never seen it in this country where a head of a parastatal, the CEO of a parastatal, when there is a duly constituted board, is sent home by State House. Maybe this one is new. The other violation is this particular one. Those are the violations. We do submit that this is the second time the governor is still being accused of usurping the powers and functions of the board. And with respect to count 4, Speaker, we do submit that the count has been proved. The last 2 counts, which I'm going to move quickly, is contempt of court. Evidence has been submitted here. How, despite the existence of court orders from Nyeri Employment and Labor Relations Court, the governor for 1 year disregarded those orders. And what the court has done, the court has convicted the governor. As we sit here today, the governor of Meru is a convict. She has already been convicted for contempt of court. That is a violation of Article 181(1)(b) of the Constitution, which constitutes a ground that where there is a which provides that where there is a serious reason to believe in that a county governor has committed a crime under the national law, the governor has already been convicted by the High Court in Meru. She's only awaiting sentence. She has not discharged the conviction. She has not appealed the conviction. That ground has already been proved. That is contempt of court. The last, the other one, of course, was illegal naming of the road. That one is okay. That one, we have said it's there. The evidence has been produced. The governor has been shown the Facebook posting whereby she's naming the road in the name of her husband. Lastly, I'll take the last one is contempt of the assembly. Madam Speaker, Section 22 of the County Assembly Powers and Privileges Act provides an impeachable ground for anybody who is a public officer who violates, who dishonors the summons of the assembly. The governor was invited to appear before the committee of the county assembly. And what she did, when she was invited, she wrote back a letter and said, there is no provision of the law which requires the governor to appear before the committee of the assembly. Yet, Article 195 of the Constitution is very clear that a county assembly or any of its committees can require, can invite, can summon, the word is summon anybody to appear before the committee to provide evidence or to give information. Section 18 of the County Assembly Powers and Privileges Act enacts the same provision and uses the word any person. When the governor, our officers were invited, when the governor specifically was invited, her defense was that the assembly goes to the High Court, files a constitutional case, seeks a constitutional interpretation whether the governor can be invited, can be summoned to appear before the assembly. Yet the Constitution uses the word any person. At Section 22 says that where the assembly passes a resolution against an individual for violating that particular provision, that shall constitute a ground for removal from office. And that's why you see this ground, and Honorable Sifuna does it. What is a contempt of county assembly? Whether it constitutes a violation. That is the only violation I've ever seen in law whereby it makes it an impeachable ground for violating, for failing to honor the summons of the county assembly. The assembly can pass a resolution and request and impeach you. And that is what the County Assembly of Meru has done. And we do submit that this count, together with the other 6 counts, have been substantiated. The Assembly has demonstrated the same. And finally, my colleague Mr. Mudomi has mentioned about, is the governor individually liable for that particular violations? She has said all these things were done by the county secretary. He has mentioned about the provisions of Section 30. Subsection 3, Section 30 or Subsection 3 of the County Government Act, which will be my last section. That where I just want to repeat what you have said. Section that talks about the governor shall be accountable for the management and use of county resources. The governor cannot run away and say, I was not the one. It was done by this officer. It was done by the county secretary. The law places the accountability at the hand of the governor. So the governor of Meru cannot run away from these allegations and say that they were done by others, that it was not her. Mr. Speaker, with that, I rest my case.
The counsel for the governor, you may now proceed to make your closing statement. You have exactly 1 hour, starting now.
Thank you, Mr. Speaker, sir, and thank you, distinguished senators. My name, for the record, is Elisha Ongoya. I'll be making the governor's final submissions. Mr. Speaker, sir, before I delve into the substantive part of my submissions, and because looking at the program of this House, this may be the last time I'm standing here to address on this matter, allow me, with great humility, to begin by thanking you, Mr. Speaker, and the distinguished senators who have given us audience despite the great time constraints that we have had to go through in making this case. I'll be failing in my responsibility for courtesy if I didn't thank the administrative staff, the secretariat staff of this Senate, who have given us significant support, both within this House and in the corridors of this precinct as we found our way around. Mr. Speaker, sir, at this juncture, allow me to proceed to the more substantive parts of the governor's closing submissions. Allow me to begin by pointing out that as a young Christian fellowshipping at Esrave Church of God deep in Vihiga County, and as a middle-aged Christian fellowshipping somewhere in Amalemba Church of God in Kakamega County, I have gathered some enduring lessons from Scripture, and I will start by drawing inspiration from those lessons. The wise man who authored the book of Proverbs, at chapter 18, verse 17, guides us as follows when we are confronted with matters such as this. In a lawsuit, the first to speak seems right until someone comes forward to cross-examine him. That ecclesiastical wisdom has found pragmatic rendition in these proceedings, as I will demonstrate shortly. Mr. Speaker, sir, the governor was presented in the opening remarks by the County Assembly's Council to this assembly, for lack of a better word, as some form of scoundrel. Fortunately, in this August House, both parties have had an opportunity to present documentary and electronic evidence. Mr. Speaker, sir, distinguished senators, when the history of this attempted impeachment of the governor of Meru County, Her Excellency Honorable Kawira Mwangaza, shall be authored, one word will be repeated in that historical text. That word is a Meru word, kibiri. I'm told, in its innocence, it is a stick that is used to stir porridge. Sadly, in that historical text that I've alluded to, that word will have no aura of innocence. I beg to pose the following questions to the hearts, the minds, and the conscience of these distinguished senators. Are we, in making a decision this evening, going to dignify the Kibiri movement that we have seen today by impeaching this governor? Are we, honorable distinguished senators, going to dignify the acts of Honorable Mpuru Waburi that you had occasion to watch today live by impeaching this governor? Honorable senators, are we today going to dignify the act of the honorable member for Buri constituency that we have seen today supporting the other acts of Mpuri Aburi that you had observed by impeaching this governor? Are we going to dignify the acts of the deputy governor for Meru County openly and in the company of the young people of this country that we ought to give proper moral guidance, calling a governor a prostitute? Are we going to dignify that person by impeaching this governor? The governor has been accused of being a leader who disrespects other leaders. Video clips of the alleged disrespect have allegedly been played here, including a song, Wenye Wivu Wajinyonge. On the other hand, the governor has demonstrated to you the sins that have been committed against her by those very leaders she is accused of disrespecting. Distinguished senators, in good conscience, are you going to vote that this governor is a greater sinner than she has been sinned against? In good conscience. How many of us can reconcile our conscience, distinguished senators, with the fact that it is the men you saw today uttering the words you saw them utter and projecting the actions that you saw them project as against the governor that have actually come to this house to complain against that governor? I've heard of the claim of pots calling kettle black. I never knew in my living history I would come across a pragmatic rendition of what that means. Today was my answer. I invite you to have that reflection, distinguished senators. I have asked myself, I invite these distinguished senators to ask themselves, Mr. Speaker, sir, where did these leaders get the moral high ground to invite this house in view of the sins that they have committed against the governor to find that the governor has sinned against them? Distinguished senators, technology has been deployed in these proceedings. We are beaming these proceedings live to the whole world by medium that will preserve them to eternity. How shall the members of this house, individually and collectively, account to their children and children's children that they ever dignified the acts of these people who have leveled a war against the governor by confirming the impeachment of the governor? We owe it to ourselves. We owe it to the peace of our conscience to make a decision that takes that into account. Choices have consequences, or so it is a truism. By impeaching this governor, if you so decide, the logical consequence is that that person you saw chanting with the young men of Meru, calling the governor a prostitute, would rise to the office of governor. Is that the desirable outcome you want out of your decision this evening, distinguished senators? Members of the County Assembly have brought the governor here. I speak the governor's heart. We do not begrudge them. They have the power to do that. They have exercised that power. Have they rightly exercised that power? Distinguished senators, that decision lies in your hand. You are told that the governor did not present the evidence that she has given before you to the County Assembly. Fortunately, this house is a house of record. Fortunately, Mr. Speaker, you have fantastic rules of procedure that, of course, we can make better, as we have seen. And I would strongly recommend, hoping time will permit, that we relook at the timelines for impeachment of governors if we have to do absolute justice in terms of filings, in terms of argument of the case. These are reform issues because we are in continuous improvement as a society. But putting all factors on the scale, we have done well in presenting some records before this House. When you retire and before you vote tonight, I invite every senator to open volume number 4 of the County Assembly's documents and turn specifically to page number 146 of that volume and look at the conversation that is taking place at that page. This is the Hansard of the County Assembly of Meru of 25th October 2023. If you turn with me to page 146, you will see this conversation. Elias Mutuma, advocate for the governor, says, "Mine will be brief, but I will not proceed until we are given a ruling on the 2 issues raised by my seniors. We seek direction on how to table the evidence that we have and how we will get a ruling on the public participation. The governor is pleading to be given a chance to table her evidence." The Speaker, Honorable Ayub Bundi, says, when your brother Omari was speaking, he mentioned a difference between honorable members and your team. He stated that he knows the division in this House and he cannot step on the other side. Anything you'd like to table in this House must go to the House Business Committee. You cannot do it when you're on that side. You must be on the side where the members are. I was wondering, Mr. Speaker, sir, how was Mr. Mutuma possibly supposed to get to the side where the members are? Was he supposed to organize a mini election in Meru County, become elected as senator for the temporary purpose of participating in these proceedings? I don't know. I am a career learner, and I learn every day. It is only allowed for honorable members. We are being told only honorable members are allowed to table evidence. You are not allowed to table evidence. We are going to make a reference to the Hansard systems because everything that you talk is being captured. You can proceed as the Speaker. The Speaker, we don't begrudge him. He had power to make a ruling. Mr. Speaker, just as you have power to make rulings here. Did he use that power correctly? That is the question I pose to the conscience of the men and women bestowed with the arduous responsibility of protecting devolved governance in this country, sitting in this House as distinguished senators. The conversation continues with Elias Mutuma, advocate for the governor, making an argument. My understanding, therefore, is that we will not lay the evidence that we have. The Speaker answers him, how will you table it, Mr. Mutuma? Mutuma is asking him, you are the presiding officer in this House. Guide me on how to table. Mr. Mutuma is being challenged. How will you do it? You are not an MCA. That is why MCAs enter through the main door, and you entered through the back door. This was no longer differentiation. This was apartheid. Discrimination on the basis of the door you entered through. Whoever entered through the main door had a chance to table evidence. Whoever entered through any other door was denied a right to table evidence. Mr. Mutuma, exercising the persistence of a lawyer that we teach in law schools, continues. My hope is now pleading hope. My hope is that you will guide me on how we will lay the evidence that we have, because I'm a stranger in this House. The Speaker answers him, we are going to rely on the Hansard system. As you talk, be aware that you are giving your evidence. He says, in desperation, well-guided, a very well-trained lawyer. Whether you agree or disagree with the judge, you say most obliged, well-guided. May we then have a ruling before we proceed?